All right, welcome back. We're still in our materials, real estate law for paralegals in chapter 2, talking about concurrent ownership. This is part 2, and we're still talking about the methods of ownership. So when we were looking at methods of ownership, we saw that there was basically two ways, right? Either individually or shared ownership. And we talked about individual ownership being called tenancy and severalty. And that concurrent ownership is just shared ownership. And we're starting to look at a couple different ways of shared ownership or concurrent ownership. And in part 1, we looked at the joint tenancy with right of survivorship. And now we're going to look at tenancy in common and community property. So remember when we talked about a joint tenancy with the right of survivorship and how title to the property passed to Cartman by his friends' deaths. And I told you when we were discussing joint tenancy with right of survivorship that you had to say the whole thing. You had to write it out. Joint tenancy with right of survivorship. Otherwise, that right of survivorship doesn't pass if you just say joint tenancy. You have to say the whole thing. Otherwise, you have a tenancy in common. So now we're going to talk about the tenancy in common, but I'm going to show you why, at least in Texas, you can't just say joint tenancy. Otherwise, you get a tenancy in common. You have to say joint tenancy with right of survivorship. So in the Texas Estates Code, it says if two or more persons hold an interest in property jointly and one joint owner dies, the interest of the decedent in the joint estate does not survive to the remaining joint owner and passes by will or intestacy from the decedent as if the decedent's interest had been severed. So that says if you have joint ownership, it doesn't automatically pass to the joint owners. It goes by will or intestacy. And remember, I told you those terms are going to come up often, will and intestacy, and so you need to get familiar with them. And then we have another provision in the Estates Code that says, notwithstanding section 101.002, which I just read to you, two or more persons who hold an interest in property jointly may agree in writing that the interest of a joint owner who dies survives to the surviving joint owner or owners. So you have to put that with right of survivorship in the name of the deed and spell it out in black and white. Otherwise, you don't get the right of survivorship. And you end up with a tenancy in common. So what is a tenancy in common? Well, this is just shared ownership between two or more people where each owner's interest goes to the heirs at death. And when we say heirs, we're talking about the folks that are going to get all of your stuff when you die, either through a will or through intestacy. Remember, with the joint tenancy with the right of survivorship, the other owners got the dead person's interest. The tenancy in common, the dead person's stuff goes to their heirs. So the tenancy in common, you don't have to have the four unities. You can, tenants in common can get their ownership interest at different time. The joint tenants can get their interest from different grantors, so you don't have to have title. And tenants in common can get different interest. They don't have to have the same size or equal interest. They can have disproportionate interest. So the only thing tenants in common really share is possession. So how does a tenancy in common work? Well, it's a lot like the same way. Say we have Scooby-Doo in the gang. Shaggy has an Uncle Stan who has an old spooky mansion. And so he says he's going to give it to Shaggy, Scooby, Fred, Daphne, and Velma as tenants in common. Now, disclaimer for this example, consider Scooby as a human. Um, Animals can't own property, so just pretend he's another dude. All right. So Uncle Stan says to Scooby and the gang as tenants in common. Well, here he might give it to them in equal shares, right? So they'd each have a fifth or 20%. And it sort of looks like it could be a joint tenancy with right of survivorship, but they could get their interest at different times. They could get their interest from different people. Not in this scenario, but they could. Um, they could also get their interest in different shares. So here, Uncle Stan could give it to the guys. Scooby and Shaggy get 35% each, and everybody else got 10%. You can't do that with a joint tenancy with right of survivorship. The shares have to be equal. So those are sort of the basic differences, but the real difference comes in when death strikes, right? So Fred dies in a joint tenancy with right of survivorship, his interest would pass to the other three, or the other four owners, right? Scooby and Shag and Daphne and Velma. When a tenancy in common, they don't get his interest. It passes to his heirs through either a will or through a state statute, intestacy statute. So that's the big difference in between joint tenancy with right of survivorship and tenancy in common. All right, so now we're taking a look at community property. So sort of the basis for community property is that we're talking about marriage. If there is no marriage or married person, then we're not dealing with community property because there has to be a marriage involved for community property to be even relevant. So always keep that in mind. So there are 8 community property states in the nation. Texas, Louisiana, California, Nevada, Arizona, Idaho, New Mexico, Washington, and then Wisconsin uses a marital property system that is similar to community property. All other states are common law. Now you may notice that all of the community property states are sort of in the west region of the country. And that's pretty much because of the Spanish, right? So they kind of ruled that part of the world at one point, and so we get a lot of influence from them where women could own property, and so you get this residual community property laws that have developed. In the meantime, the rest of the country, right, was sort of subject to the English common law and the way they did things, and that's why the rest of them have their system the way they do. So we are in Texas, right? I'm in Texas, the school's in Texas, a lot of my students are in Texas. So we're going to be talking really kind of specifically about Texas community property when we have this discussion because I'm not an expert in every other state's community property system or their common law system. So when we talk about stuff related to community property, it's going to pretty much be Texas specific because that's where we are. So before we get to understanding community property, we have to understand separate property. So separate property is property that is owned by a married person in his or her own right during marriage. Or at least that's the way your book explains it to you. But here in Texas, separate property is defined in our Constitution. Article 16, Section 15 says that all property, both real and personal, of a spouse owned or claimed before marriage and that acquired afterward by gift, devise, or descent shall be the separate property of that spouse. Now, we'll notice a few things. It says all property, both real and personal, right? We learned about real and personal before. So we're talking about houses, cars, pets, jewelry, everything, right? All property, both real and personal. That's owned or claimed before you get married. And anything that you acquire afterward by gift, our old friend gift, right? Remember that. Devise, we've heard that before, right? That means by will. And descent. So this is a new term, but it just means without a will or through intestacy, otherwise inheritance, right? So that's what Texas says descent is without a will. So that's separate property. It's also defined in our family code, right? So it says separate property, a spouse's separate property consists of the property owned or claimed by the spouse before marriage, property acquired by the spouse during marriage by gift, devise, or descent, and the recovery for personal injuries sustained by a spouse, except any recovery for loss of earning capacity during marriage. Notice this except earning capacity, right? So you think of your earning capacity, that means your paycheck. If you're married, just FYI, your paycheck is community property. Every dollar you earn is half of your spouse's, at least if you're in Texas. So always think about that when you think about marriage, the joys and sanctity of marriage. All right, so now that we know what separate property is, now we can talk about what community property is. So your book says all property acquired during marriage owned in equal shares. In Texas, the statute says community property consists of the property other than separate property acquired by either spouse during marriage. So community property is everything other than separate property that you acquire while you're married. So you have to know what separate property is in order to know what community property is, because it's sort of a definition by exclusion, right? So everything that you get before marriage by gift, devise, or descent during marriage is separate. Everything else, community. So this battle or decision making on what is separate and what is community is important for real estate and for really family law, because that's where it comes into play. And this trying to determine, is it community or is it separate, is called characterization. And so that just means the process of classifying marital property as either separate or community. And that's important, mainly for divorce, but also in death, determining whether something's community or separate, because depending on its characterization is going to depend on who has a claim or right to that property. So What you need to know what tenancy in common is, difference between separate and community property, especially here in Texas. And that should wrap up chapter 2.